you want your public to have full input, full notice, and full accountability of what you are doing. Transparency is the key. And members of the public, this is the other piece that gets really critical as part of Cure and Correct, public participation and comment. This is what the intent of the law is. You want to give the public the right amount of information, all the information possible that you're operating with, so that they know that you're making a decision based upon X, Y, and Z. And everybody is on the same page with those same X, Y, and Z baselines. Now, Brown Act violations, and this is just for public consumption here. If you have a board member who attends a board meeting where you take action, and where the member is actually trying to deprive the public of the knowledge, okay, that gets you into the criminal arena. But if you don't have any knowing intent of going in, trying to hide information from the public, you're not looking at any kind of criminal action. And of course, as you know, it's the district attorney's office or any interested person can bring this civil action to stop or prevent violations of the Brown Act. So before a person can bring a civil action, they have to bring a cure or correct demand that must be served on the government. What that is the member of the public or the district attorney's office has to give the board notice of what they think you've done wrong and an opportunity to correct the violation if it's a violation. The other piece is if, and this is hypothetically speaking, if an entity brings a cure and correct action and the board decides not to do it, and eventually a violation of the Brown Act is found, the prevailing plaintiff is entitled to attorney's fees. And for closed session, we have a closed session violation as well. For closed session violation, the court can order that all closed session meetings from now on are actually. Okay, so the demand to cure and correct can be made by anyone in the public. And the demand must be made within 90 days from the date action was taken. So if it's action that the board has already taken, the timelines are 90 days from the date, unless the action was taken in open session, in which case the demand shall be made within 30 days from the date that action was taken. So there is that statute timeline or time frame that the legislature has contemplated with respect to public entities when the public has the right to bring these kind of demands to cure and correct. This is, I think, the most critical piece. The fact that a body, such as a school board, they take subsequent corrective action. So a member of the public says, violation of the Brown Act, cure or correct. And the board says, okay, we'll cure and correct it. That doesn't mean that the board is actually admitting liability, or the board is saying that we did something wrong, and it won't be used as an admission. And neither shall it be used as evidence of a Brown Act violation. So if you cure and correct it, that next step where the plaintiff can take it to the civil action in a lawsuit to a civil court, that doesn't need to take place. What I want to be very clear about is that any remedial measure that the board takes when it does a cure and correct does not automatically mean that you're admitting as evidence of a violation of the Brown Act. And I think that is ultimately the key with respect to cure and correct cases. The law is intended for transparency. The law is intended for the public to hold its elected officials accountable. The law talks about structure. The law talks about timeline. The law talks about protections. And ultimately, the intent of the law is that elected body do its business in front of the public, and that's the intent of the law. So that's pretty much my overview on cure and correct, very short, as requested, and I'll be happy to take any questions if there are.
I have a question, just sort of based on our proceedings that we've had so far. Would it be proper for a board, our board, to consider a letter received by the board before going into a closed session if it wasn't agendized for that closed session?
Okay, so we're really not talking about cure and correct at this point. We're talking about
a Brown Act violation? Is that what?
So we're not talking about cure and correct at this time. We're talking about whether or not there is a Brown Act violation with respect to a closed session issue that may or may not be agendized. So is that part of this discussion? Because my information is on the Cure and Correct piece here. So if you're asking me specifically with respect to a closed session agenda, I don't think it's agendized as
And I
part
think that
of
asked you to render an opinion. We weren't asking for that, we were asking just for the general public information around the Cure and Correct process, since that was related to our agenda.
Well, and I think her question, I think, is more about a closed session around that violation and not with respect to Cure and Correct. And if I'm misunderstanding, please.
No, you're correct. You were just talking about Brown Act violations and what caused Brown Act, how you can have a Brown Act violation. So I was just wondering if that kind of thing would be a Brown Act
Well,
violation.
I think the Brown Act has very specific guidelines as to what happens with respect to the agenda placement, with respect to what can be considered in closed session. And so I'm not sure what specifically we're talking about, but I would have to review the actual incident and the agenda for that day to determine whether or not it's a closed session violation. Any other questions?
Okay, thank you, Ms. Brown. Sorry to make you wait so long to do 15 minutes, but we appreciate your coming in and just hitting the highlights of that. Next on the agenda.